Hello, this is Matt on the Moon Lambo channel, and this is huge news. What a victory today for the XRP community. The judge has granted attorney John Deaton with AMICI status, and so he will, along with movements, influence the the SEC versus Ripple lawsuit. Gigantic news. And it's so interesting. I got a lot to unpack in this video. So I've got opinions from 3 attorneys. Also opinion from Stuart Alderati, who is Ripple's general counsel. I got a quick tweet from Ripple CEO Brad Garlinghouse on this. We've got analysis that will also indicate that from the judge who made this decision today, that there's no precedent for what is happening here. There is no precedent. This is astonishing. This is a big deal. There's like no case law to look at and draw upon a conclusion to what would be a reasonable path forward. And so here we are in uncharted territory, and this is fantastic for the XRP community. So the judge does seem to recognize what we've been saying, that the SEC is wrong in their assertion that our position is absolutely adequately covered just by Ripple being in the case. We know that's not true. Nothing against Ripple, but their incentives and what they're fighting for is different than what the XRP community is going for. It's just not the same. So this is absolutely fantastic. But before going any further, I do want to be clear that I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who makes crypto-related YouTube videos, but just as a hobby, just for fun. And so here you can see, this is just, I'm not going to read this article. I've got a bunch of other stuff that I want to run through, but I highlighted this article from Reuters on this topic just to point out mainstream media is following this, and increasingly so. Here's the first news of this on the entire planet to break. Here you go from John Deaton's Crypto Law. Breaking. Judge Torres grants AMICI status to John Deaton and movements and denies motion to intervene in Ripple versus SEC. And so it is true that the motion was technically denied, but that's just because, without getting into the nitty-gritty, effectively the implications of that were greater than what the judge wanted to occur within this particular case. And so rather than say, no, John Deaton and movements, you all go away, the motion was technically denied, but again, AMICI status was granted, and so the opinions of John Deaton and movements will be there to influence the court, which is what the judge today said she wants. So this is good. So it's really just a technicality. You can see the negative sounding words, denies motion to intervene. It doesn't matter. This is a win. This is absolutely a win. Here's XRP community member and attorney James K. Filan, who wrote the following. Breaking. Court gives John Deaton power to brief questions of law on behalf of individual movements. This is a huge win for the XRP community because the interests of the individual movements and the XRP community are aligned. Court stated that, quote, movements in their individual capacities shall be permitted to act as amici curiae in this action. As such, movements shall be allowed to assist the court by briefing legal issues relevant to the case as approved in advance by the court. The court contemplates that such assistance will be most beneficial during briefing on dispositive motions, but may exercise its discretion to request or deny further applications as appropriate, end quote. And then here are big congratulations to John Deaton. Just look at this. John Deaton just came out of nowhere December 2020. And I am very thankful for that. This is, and Ripple knows this is a win too. This is the right path. The crazy assertions that the SEC has that every single XRP transaction, even today, represents, an exchange of an unregistered security. Even parties that have nothing to do with Ripple. That it's such a bonkers assertion. So grateful that John Deaton's going to be there to help guide the court. Here's a tweet from attorney John Deaton himself. And he was retweeting what I just shared with you from attorney James Filan. And John Deaton wrote, "Thank you, Jimmy. Everyone in this community knows that Jimmy Filan is second to none when keeping XRP holders timely informed. This court decision was no different. Jimmy allowed Crypto Law US to post it first because he's not only a legal scholar, but also a gentleman. I thought that was nice. I mean, and indeed, it is a case that James Filan, for those of you not in the know, every time there's a legal filing having to do with the SEC versus Ripple case, he publicly posted on his Twitter account. I go there all the time for information that I end up covering in my videos, because it's just the easiest place for me to look to see where the most recent legal documents are. And isn't it kind of him here? Let John Deaton's Crypto Law make the first announcement of this. That's cool stuff here. And here we have Stuart Alderati, General Counsel of Ripple. Over 35 years of legal experience with expertise in banking, regulatory affairs, and complex litigation. And he retweeted this from Crypto Law, and here's what he wrote. XRP holders have always said that the SEC's lawsuit is a direct attack on them. Now it's official. The court's ruling permits John Deaton to share his meaningful perspective, that's a quote by the way, to help the court reach a proper decision. Yet another important and positive development. Indeed it is. And here's a one-liner from Ripple CEO Brad Garlinghouse. He retweeted that from Stuart Alderati and simply wrote, "Today was another good day." There's a lot of those, aren't there? Seriously, you think about it, the developments, how things have unfolded for the last 9 months. The vast majority of information that's been coming out from pretrial hearings and such, it's been very positive, and the court's been very on the side of Ripple to this point. So here you go, just another good, fantastic day. And here's what attorney Jeremy Hogan had to say. He, of course, is the guy who runs the very popular YouTube channel Legal Briefs, and he wrote the following. Congratulations, John Deaton and XRP holders. You now have an official voice in the Ripple vs. SEC case. AMICI curiae, which is what the judge granted, status, allows you to file an official brief which the judge will take into account when making her final decision. And then, let me sure, oh yeah, okay, sorry, I was just making sure I'm not losing my spot here. Then there's this, and this is interesting. You guys are going to love this. So here's another comment from attorney Jeremy Hogan. He wrote, this order is only the second thing we've seen from Judge Torres. I like this official finding by the judge that XRP holders and Ripple have a common interest, because it's a concession by the judge that a ruling against Ripple is a ruling against all owners of XRP. See, look, folks, she absolutely gets this. This is fascinating here. And so here's the screen grab that Jeremy Hogan shared from what the Judge Torres wrote here. Here, movements and defendants have an identity of interest because they share the identical ultimate objective. Right, and then said, applying the presumption where movements and the party had the same ultimate objective, even if they had different strategies and motives for achieving that objective. Both movements and defendants seek the same outcome, a holding that XRP, particularly XRP currently being traded, is not a security. Compare movement memory at that. There's some lines there. It doesn't matter. I don't need to read that. That's just gibberish anyway. But you guys got the gist of what the judge was getting at here. And then there's this XRP community member XRP Crypto Wolf wrote to Jeremy Hogan here on Twitter and said the following: Judge Torres allowed John Deaton and individual movements to be friends of the court, but why can't they offer evidence or present witnesses? And Jeremy Hogan shared the following. Deaton can't present new evidence because it would raise a due process issue. Ripple's side would be able to present Ripple's evidence plus Deaton's, and that's not fair. Now, that said, there's no reason why Ripple can't introduce evidence that Deaton has found, etc. And somebody named Kofi responded to Jeremy Hogan there and wrote, that throws more questions as to why it seems Ripple has not been presenting this information already. It's there on the internet. Or have they, and the courts are ignoring it for some reason? Something just doesn't seem right about all this. And Jeremy Hogan said the following in response to that. He said, we haven't seen even 10% of the evidence yet. We are just seeing bits and pieces right now. Yeah, indeed, so nothing's weird to this point. We're not going to be privy to that type of stuff for some time. And then there was this. Somebody named Curse Knowledge wrote to Jeremy Hogan and said the following. So the digital asset investor researches for John Deaton, who hands DAI's valid research up the ladder to Solomon's attention. That's Ripple's employee, we're talking about Matt Solomon there, who can then bring it to the judge's attention, question mark? Talk about a game of telephone. Yeah, I know, I was kind of thinking that too. Jeremy Hogan wrote, that could very well happen. As long as the evidence can be properly authenticated, is relevant, not hearsay, etc., it can come in. And I'm willing to bet a bunch of it's going to make its way to the case. And then there's this. This is highly interesting. Take a look at this. Here's what Jeremy Hogan shared. And he also has a screen grab. I'll make that full screen in just a second here. But Jeremy Hogan wrote the following. Look at this from Judge Torres's order granting amicus status to XRP holders. Yes, Judge, a lot of things about this case are backwards. Why would 22,000 XRP securities holders want to intervene as defendants in a case where the SEC is supposed to be representing them? Yeah, and so I'll just say this, and I've long thought this is ridiculous. The SEC has publicly argued that John Deaton and the rest of the movement should not be allowed to intervene in the case or have any sort of presence in the case whatsoever because their interests are sufficiently represented by Ripple, the company. Which just seemed, that always seemed backwards to me because it's supposed to be the SEC that has the interests of investors at heart, but they have publicly stated, no, it's Ripple that has their interests at heart. And I'm just like, well, this is a first in the history of mankind, right? And it does seem to look that way. Take a look at this screen grab and look at the part that Jeremy Hogan highlighted here. This is from the judge who wrote the following. There is no case law that addresses the specific circumstances presented here where unrelated individuals seek to intervene as defendants, effectively requesting that the court compel the SEC to take enforcement action against them. But yeah, exactly, by being included in the case. Nothing like this has ever happened before. And then somebody from the community named Andrew wrote to Jeremy and said, reading down the comments and notice that nobody has copied Charles Gasparini yet. So that's, of course, the Fox Business Network journalist who's been covering the story lately. And then Andrew says, I think he would find this unique circumstance of interest. And Jeremy Hogan responded with the following. To me, this is the most interesting part of this case. That the very people the SEC is supposedly protecting have banded together against the lawsuit. The judge literally could find no historical case authority that addresses this situation. It's pretty wild. So this should, look, in my opinion, this should show you just how off the mark the SEC is. They're wrong. They're on the wrong side of history, and their behavior is absolutely reprehensible. It absolutely is. And then there's this. Somebody named John wrote to Jeremy Hogan and said, Jeremy, from her response, do you think this is the judge asking the SEC to acknowledge that if they don't drop the claim that XRP is currently a security, then she will be forced to look upon us holders and Ripple as one, to provoke the SEC to drop the claim it's still a security? And Jeremy responded with the following. Judges do that sometimes, throw hints at parties. If that is what she is doing, it's very subtle. Yeah, so I don't know if she is or isn't, and indeed, Jeremy's right, it would be rather subtle if the case, but if the SEC wanted this to not happen, all they had to do was say that the XRP being sold today does not represent a security just by the nature of it existing. They could have just been more specific instead of being overbroad, just gone after Ripple for previous sales of XRP. John Deaton wouldn't even be a thing then. But that's not what they did. It's a really broad overreach, and now they're having to deal with the consequences. And so that's where we're at, guys. That's it. Happy news. This is fantastic. What a victory for XRP holders today. And so I've been looking forward to seeing what the judge would determine on this for months and months and months, just like everybody else. I was cautiously optimistic, and so this is good. And you never know when something like this is going to come down. The next thing that I'm really looking forward to seeing, and you're not going to know when this comes either, is out of the blue. We'll just wake up one morning, and then there it will be. News of settlement between the SEC versus Ripple. That's what I'm counting on. Don't know for sure what's going to happen, but that's the biggest of news. And I think it's going to come at some point, and that will be an even bigger pleasure to report on. But I'll go ahead and wrap up here. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.